COVID-19. The team is Rose Rebel and another against the Federal Republic of Nigeria. My lords, the applicant is represented in court by counsel. The respondent is absent and not.
The ECOWAS Court of Justice holds an external court session in Accra, Ghana. The panel is constituted of 3 judges from different countries in the region. It is a hybrid sitting. Some applicants and their legal counsels put in physical appearance, but other counsels appear before the court virtually.
Dorothy Friye Ansa, Chief State Attorney. For the 6th defendant.
They make their oral submissions. There are simultaneous translation into the 3 community languages, Portuguese, French, and English. The judges deliver their judgments.
The bundle of evidence does not attribute any persuasive proof pointing to the discrimination against the applicant that will aid this court in its determination.
All the proceedings are streamed in real time. It is a seamless process. This is the contemporary face of the ECOWAS Court of Justice. It is the culmination of its evolution over 20 years as the principal judicial organ of the community. The ECOWAS Court of Justice was first conceived under the May 28, 1975 Lagos Treaty, which established the 15-member Economic Community of West African States ECOWAS for the economic integration of the region. The treaty made provision for a tribunal of the community to ensure the observance of law and justice in the interpretation of the provisions of the treaty. It was also to settle disputes that may be referred to it in accordance with Article 56 of the treaty. However, this was not given effect. In 1991, ECOWAS heads of states and governments adopted a protocol establishing the court as an interstate court and the principal legal organ of the community. Still, the court did not take off. In 1993, the revised ECOWAS Treaty was adopted, replacing the initial Lagos Treaty. Articles 6 and 15 of the revised treaty established a Court of Justice of the community. Its territorial jurisdiction covered the 15 ECOWAS member states. The treaty vested the court with the cloak of an administrative tribunal for ECOWAS officials and the community. It was given the responsibility of applying and interpreting ECOWAS community texts under the 1991 protocol. However, it was not until December 2000 that the pioneer judges were appointed to the court. There were 7 in number. Justice Hansin N. Dunley, Nigeria. Justice Awa Nana Daboya, Togo. Justice Anthony Alfred Benin, Ghana. Justice Sumana Diraru Sidibe, Niger. Justice Aminata Male Sanogo, Mali. Justice Barthélemy Toi, Burkina Faso. And Justice El Mansour Tal, Senegal. The pioneer judges were sworn into office on the 30th of January 2001 in Bamako, Mali, 20 years after the court was created.
We were sworn in Mali by the then president of the Republic of Mali and the chairman of the authority. We conducted election there because, you know, the post of the president and vice president then are elective. They are not by appointments. So the judges appointed Justice Stahl and myself as the Vice President and President of the ECOWAS Court of Justice. And at that time we were in Mali. We didn't know where the court would be, but the then president of Mali said the temporary court will be in Abuja. And because we did not know what arrangements have been made, the judges, 7 of us, mandated me, since I was from Nigeria, and then the first president, or the founding president, mandated me to come back to Abuja and see how I would set up and then invite all of them to come so that we will commence work. And that was what I did. When I came, I went, of course, to the main, the ECOWAS Commission. The then executive secretary said they were not ready, but after some time, they were ready for the court. And we were given a temporary room to start our operation. So, with that one room, we got the treaty protocol, and we started. But the judges were still in their home countries. So we started also, the second step was to invite them to come to Abuja so that we hold our first meeting. We had our first conference and we looked at the treaty and the protocol to see what should be done. And we were anxious to start our operation. So when we met with the President of Nigeria, President Olusegun Obasanjo, he said there was no accommodation yet for the court and all the judges. But they're going to give us a temporary place in Lagos. That is the Senate building in Lagos, and where to stay.
The temporary seat of the court was located here at the old National Assembly building within the Tafawa Balewa complex in Lagos, Nigeria.
We met in Lagos in 2001, August, and they had designated the old Senate building in Lagos to be the court or office for the court. So we went there. The place was okay for a court, but then there was no residential accommodation for any of us. So it's going to be difficult to stay there. And to be honest, we found life there a little difficult. Traffic, having had to get into the courthouse was a problem. So we voiced our concerns to the then Nigerian head of state, His Excellency Olusegun Obasanjo.
We took occupation of the Senate building, organized the conferences. I set out the rules of operation, what are the serious issues to be taken. And one of them was to discuss our rules, because without the rules, the court cannot operate.
The pioneer judges drew up the draft rules of procedure for the court at their second seminar in Lagos. It was essentially anchored on the rules of procedure of the International Court of Justice as well as the Court of Justice of the European Communities, with some modifications.
À Lagos, nous avons passé banalement un mois, mais on a sorti ce que nous appelons le règlement intérieur, le règlement de procédure.
Officers from member states were invited to look at the draft of the rules of procedure to see whether they are in consonance with what they perceived the rules to be.
The draft rules were presented to the ECOWAS Council of Ministers in December 2001 in Dakar for approval. The 25th session of ECOWAS Heads of State and Authority, also held in December 2001 in Dakar, Senegal, decided that the seat of the Community Court of Justice should be located in the Federal Capital Territory of Nigeria. In January 2002, the court consequently moved from its temporary location in Lagos to its permanent seat in Abuja.
March 2002, they told us they've moved the headquarters to Abuja. They've gotten accommodation for us, so we should come. So I went to Nigeria, I think somewhere towards the end of March or April 2002. Was it 2002? So we went there, and then we had accommodation at Gwarimpa for all the judges.
When we came back from Lagos, we're still in our temporary office in the ECOWAS Commission until Nigeria could get a place where the court is presently occupying. And then we continued reconstruction to suit a setting of a courtroom, because not only the offices, there must be a courtroom. So we converted the store that was attached to the building into a courtroom. And you know, that is a long process.
On the 15th of July 2002, the court moved to this complex, which has become the seat of the ECOWAS Court. Elements of the requisite court bureaucracy were emplaced and some critical court infrastructure installed. The ECOWAS Council of Ministers approved the rules of procedure for the court on the 28th of August 2002 to facilitate its operation. The year 2002 therefore marked the crystallization of the court from a concept to a physical reality. The court was now set to begin business. However, there were still more hurdles to overcome.
How to start business? We looked at the protocol and found that our jurisdiction was very circumscribed, limited to only institutions of ECOWAS and member states. Which member state was going to bring which member state before the court? Which institution was going to have the courage to bring a member state before the court? So we found that virtually, if we have to stay there like that, we will be there for the 5 years and nothing will be done.
The jurisdiction of the court, as contained in the 1991 Protocol on the Court, was rather narrow and restrictive. Article 76(2) of the revised ECOWAS Treaty expressly limited its mandate to disputes between ECOWAS member states or between member states and ECOWAS institutions on the interpretation or application of the treaty. It also stipulated that only a member state could initiate proceedings against another member state or institution of the community on behalf of its nationals. This meant that individuals could not approach the court directly with their grievances.
We found that if that protocol was not amended, we have no job to do, because they will be settling their issues among themselves, and then the citizens will be cut out of ECOWAS. Because when there's a community like that, there must be friction.
The court eventually held its inaugural sitting on 22nd January 2004. The first case in the history of the court was filed by Olajide Afolabi against the Nigerian government.
The government of Nigeria closed the border between Nigeria and Benin Republic. The first Olajide Afolabi, who brought the first case before the court, seized that opportunity that he had business transactions, he had to needed to conclude in Benin Republic, but because of the closure, he couldn't go to Benin Republic. So he filed an application challenging the closure of that border, violation of his right to free movement, and asking for compensation. The court did not waste time in considering the application, since it was the very first one coming before it, but ruled that Olajide Afolabi, they don't have the local standard to come before it, since individuals at that point in time did not have direct access to the court.
Mais c'est quand nous nous sommes penchés sur le dossier Afolabi que nous nous sommes rendus compte que nous ne sommes pas au bout de nos peines. Parce que Afolabi, citoyen nigérien, saisit la cour contre le Nigeria, son propre État. Vous voyez le Nigeria en train de venir à la cour pour appuyer qui? Parce que le représentant de l'État du Nigeria, c'est le ministre de la Justice. Il va comparaître devant nous. Il va défendre qui?
The court was not seized with the powers to amend the protocol to cure the defect. The statutory power to amend rested with the powers that established it.
We sat down, we discussed it at length among the judges, and then found areas where we could ask for the mandate to be expanded. We drafted something, and then it was decided that if we decide to just pass it on to the Council of Ministers, it will never pass. So we should try to get the member states, get them one-on-one for them to appreciate what we're talking about. So we sent out delegations to various member states. Some came to Accra, Senegal, Mali, Niger, to convince the various member states that there was a need to expand the court's mandate to make it meaningful.
The leaders of the West African Bar Association met with the management of the court to explore ways of making the court effective and functional. After the meeting, we came to the conclusion that we needed to mount a campaign for the expansion of the mandate of the court.
When the ministers of ECOWAS saw the need to amend the protocol to give every citizen the opportunity to come before the court if they are aggrieved or if their rights were violated, they approved the amendments.
The ECOWAS Council of Ministers saw the light and acceded to the amendments with the adoption of the 2005 Supplementary Protocol in Accra, Ghana. The Supplementary Protocol expanded the jurisdiction of the court and conferred it with 4 mandates as 1. A community court, 2. An ECOWAS Public Service Tribunal, 3. A Human Rights Court, and 4. An Arbitration Tribunal. The court now had the jurisdiction to determine cases of violations of human rights that occur in any ECOWAS member state. Individuals with any complaint of human rights violations against state actors were conferred with the legal right to approach the court directly. This was, however, contingent upon the fulfillment of 2 conditions: that the application must not be anonymous and the matter must not be pending before another international court. An important provision unique to the court was also introduced, stipulating that there was no requirement for an applicant to exhaust domestic remedies before filing an action before the court. Individuals did not therefore need to pursue judicial remedies within their national court system before bringing a claim to the ECOWAS Court of Justice.
Because that will take a long time, don't you think so? So any violation can be brought timelessly before the Court of Justice. And I think we achieved by that amendment.
This was a transformative moment in the history of the court. Its role and relevance in the judicial landscape of the region was profoundly impacted.
The court's history can be divided into two phases: pre-2005 and post-2005. 2005 being when, 19 January 2005, when the supplementary protocol that adopted the initial protocol of the court was adopted. When this supplementary protocol was adopted in 2005, we observed that before the December that year, in 2005, 6 cases were lodged in 1 year.
Cases began to pour in from individuals, not member states now representing the individuals.
However, the judges coming from the different legal systems in the 3 linguistic zones of ECOWAS, English, French and Portuguese, still had to sort out how to work together. Finding some harmony would facilitate the common legal reasoning to enable them deliver on their judicial function.
7 juges, dont 5 de tradition francophone et 2 de tradition anglophone. Et certes, pour entrer à la CEDEAO, il faut pratiquer au moins 2 langues sur les 3. Sur nous les 7, nous étions, je dirais, à peine, juge Donly et moi, pouvions bricoler un mot dans les 2 langues. Voilà pourquoi, très vite, nous-mêmes, on a dû imposer une 3e langue, qui est la langue de la communauté, qui est le Hausa, pour qu'on puisse... Donc déjà, c'est des difficultés pour qu'on se comprenne.
From 2005, the court, now vested with expanded jurisdiction, came to life. There was a surge in judicial activities. The human rights mandate immediately became the most popular. Individuals and corporate organizations across the region took to the court to seek judicial redress for human rights violations by member states.
Post-2005, the centerpiece of judicial activities of the court has become the human rights mandate of the court.
The years 2001 to 2005 constitute an important phase in the history of the court as the foundation years of the court.
To get all this translating equipment, it was all within that period. To get translators, to get interpreters, to work with the courts, and to get all the outfit, the ropes, and then to start hearing cases cannot be said to be easy. That is why sometimes I didn't want to even remember those formative years, because they were difficult years.
Faço parte do segundo grupo de juízes que chegam ao tribunal para substituir 3 dos juízes iniciais. Portanto, eu cheguei ao tribunal porque sou o primeiro juiz lusófono a chegar ao tribunal. Antes, tinham estado no tribunal apenas juízes francófonos e anglófonos. Portanto, eu sou o primeiro juiz de países de língua portuguesa que começa a trabalhar no tribunal, o que dá uma ideia de uma maior amplitude do tribunal. Isto é, o tribunal já passou a exprimir os 3 grupos linguísticos que integram a nossa comunidade.
Creating awareness on the establishment of the court as the principal legal organ of the community was imperative. Intense sensitization was given priority to make the West African community aware of the mandate and powers of the court, as well as how to access it. The court engaged with diverse segments of the community in member states, its contemporaries across the world, as well as international development partners.
We went around the ministries of integration and made our presentations so that they are fully with us. No state will now say, we don't know about the court, we don't know about the activities of the court, we don't know its seriousness, we don't know its jurisdiction.
The ECOWAS Court around that time came and they publicized their protocols and that type of, there was some training done in Sierra Leone. That was when I knew about the court.
The sensitization program has now become a recurrent feature on the court's annual calendar. It keeps the court in public consciousness and reminds the community of the judicial option in the conflict resolution spectrum.
Since we came in 2018, it was my agenda that we're going to visit at least 3 countries to do sensitization every year. And therefore, in 2019, we visited 3 countries. 2020, we visited just part of it, then COVID came in. And when we go to the countries, it is the grassroots, the market women, pressure groups, interest groups that we used to meet to educate them, let them know about the court, what the court does, the procedures, if you want to file a case, the kind of rights that they can bring before the court.
Another critical initiative of the court is holding external sessions in member states. Article 26(2) of the 1991 Protocol stipulates that where circumstances or facts of the case so demand, the court may decide to sit in the territory of another member state. Flowing from this, the court embarked on external sessions outside its seat in Abuja.
E organizar a ação externa de julgamento. Qual é a função dessa sessão externa? Primeiro, a justiça ao alcance do cidadão. Nós procuramos que os países limítrofes, com processos de pessoas carentes que não tenham capacidade para financiar toda a logística de deslocação a Abuja, e organiza-se no Estado-membro. E nesse ano organizamos aqui na Guiné. Foi também bastante interessante, por um lado, e por outro lado também permitiu uma interação com os órgãos de soberania do Estado da Guiné-Bissau, tanto a presidência como a presidência do Conselho de Ministros, tanto o Primeiro-Ministro foi visitar, o Presidente recebeu-nos, o Primeiro-Ministro recebeu-nos na altura, o Presidente da Assembleia recebeu-nos, o Presidente do Supremo Tribunal de Justiça também nos recebeu. Portanto, isso ativa um bocado de relação entre os políticos do Estado onde se está a realizar isso e o nosso Tribunal, dá a conhecer a população, para além da justiça ao alcance de todos, dá a conhecer a população as competências do Tribunal, o programa, como funciona, e de facto permite que os cidadãos conheçam melhor a CDAO.
Eu já não consigo ver a CDAO ser o seu Tribunal de Justiça, porque os cidadãos vêm respeitando cada vez mais o Tribunal. Portanto, eu gostaria de ver o Tribunal a continuar o seu trabalho e a continuar a granjear o respeito dos Estados-membros e também da comunidade jurídica que integra a CDAO.
The court held its first 2 external sessions in 2007 in Bamako, Mali, to hear the case of Moussa Leo Keita and the Republic of Mali, and delivered a landmark judgment which has become a legal precedent on the competence of the court. Another notable external session was held in 2008 in Niamey, Niger Republic. The court heard the now famous case filed by Hadijatu Mani Karau against the Republic of Niger over the practice of slavery in some communities in that country.
Évidemment, les militants des droits de l'homme du monde entier, à commencer par la Fédération internationale des droits de l'homme, tout le monde était venu. Et en une semaine, nous avons siégé. Et c'est ça aussi l'avantage de la Cour de justice de la CEDEAO. Il n'y a pas de frontières, même de langue. Parce que à Niamey, nous avons siégé, c'est une cour moderne de droit et tout ça, nous sommes des francophones. Mais les débats se sont déroulés aussi bien en français qu'en Aoussa et en Djebarman. Pour que tout le monde comprenne, parce que c'est toutes les femmes du Niger qui étaient intéressées. Et nous avons vu aussi l'apport des médias dans cette vie. Donc nous sommes allés 2 fois. La première fois, on a passé toute la semaine, 4 jours, à instruire le dossier. Puis nous l'avons mis en délibéré. Nous sommes revenus à Abuja. Nous avons travaillé notre dossier et nous sommes repartis pour rendre la décision.
After Khadija's case, there's a lot of cases that have been followed because the Khadija case was a precursor of the right of citizens of ECOWAS from Niger to go and complain. Not only Niger, many of individuals have been encouraged by seeing the case of Khadija from Niger have been a success.
The external sessions continue to be a critical part of the court's tradition. Over the years, the court has sat in Niamey in Niger Republic, Ouagadougou in Burkina Faso, Porto Novo in Benin Republic, Ibadan in Nigeria, Lomé in Togo, Bissau, Guinea-Bissau, Bamako in Mali, Abidjan, Côte d'Ivoire, and Accra, Ghana.
The external court section is one of the core programs of the court. Even in the phase with the introduction of the electronic system at the court, it's still important that the people feel the presence of the court in person. And so that program is still was relevant yesterday and is still relevant today. We try to fund it at best within the limited budget ceiling that we have. The envelope we have to work with sometimes impact where we have the court, despite the fact that the court tried to balance things out, but the envelope also has an impact to play.
The full complement of the court moves for the external sessions. It also facilitates interaction with national court systems for better synergy. This session in Accra, Ghana, attracts the presence of President Nana Akufo-Addo. It is an acknowledgement of the increasing importance of the court to the community.
By coming to Accra, the court is giving Ghanaians the opportunity to observe the court in session. It also serves as an outreach program to sensitize community citizens about the workings of the court. I commend the court for the work it is doing in the discharge of its various mandates, particularly its human rights mandate.
The court has also kept faith with the legal year tradition. Launching the legal year is another prominent feature on its annual calendar. It provides an annual platform to review the judicial activities of the court and its programs for the year.
Of the legal year of the ECOWAS Court of Justice. My assignment.
In 2020, however, the court could not abide by this tradition. The coronavirus pandemic struck and the whole world momentarily came to a standstill. This would prove to be another watershed in the history of the court. For the first time since it commenced intense judicial activities in 2005, the court could not sit for an extended period of 6 months. It took judicial notice of the pandemic and adjourned all proceedings sine die, but access to justice had to be sustained in the interest of litigants. The court turned to technology and adopted a virtual court system to keep the wheel of justice turning.
Now, this technology came suddenly, whether good or bad, through COVID. And it was very clear we could have Zoom meetings. So the idea was that, fine, if we could do this, why don't we put the infrastructure in the court for the court to also use it? And so therefore, we started gradually, we bought all the equipment that we needed for the court and even for the deliberation room where we have other meetings. Then the highway had been opened. We tested it and it was very efficient.
This has facilitated the development and introduction of the Electronic Case Management System, ECMS.
With ECMS, the idea behind is to make all the services provided by the court accessible to the citizens by just clicking on an interface. So today, if you want to file a case, you get on your computer and then you file a case. So we wanted to make that accessible to the citizens from wherever they are, as long as they meet the requirement to interact with the court. So that's the idea behind the ECMS. You have a catalog of services that are available to the fingertip of the citizen.
You can even hire a lawyer just to prepare the documentation for you. If he does it, you are good to go. But once you file it, gets to us, the respondent will be served electronically. He also responds, and the matter is ready for hearing. If it's ready for hearing, you sit in the comfort of your room, your house, you log onto the system. So somebody can file a case, get judgments.
The court in May 2020 issued a new practice direction on electronic case management and virtual court sessions. It provides for electronic filing and service of legal documents, preparation and conduct of virtual court sessions, judgments and rulings, and incorporates provisions for physical court sessions. The ECMS has radically changed the way the ECOWAS Court of Justice operates.
It's a hybrid hearing, so if you could decide to come.
My name is Nkem Akolam Okoro. I represent the applicants in this matter. May it please my Lord.
Merci beaucoup pour la présentation.
I think the new practice directions on the virtual court systems that were released by the court have been very positive, and I think it's enabled more access to justice, because previously, to be a litigant before the court, you need to be able to afford the expense of traveling to the court. But with the new practice directives, you can appear from the comfort of your house, the comfort of your office. I think it's really made the ECOWAS Court, it's brought the ECOWAS Court to the doorsteps of litigants, yes.
The court has also invested in contemporary technology to support the multilingual backbone critical to the conduct of its judicial operation.
We had specialized applications such as Multitrans. Multitrans is the translation management system, which is built around a centralized database. So the translators of the courts have a centralized database, and they are building their terminology in text basis. At the end of the day, what is built by a group of translators can be used by another group of translators when they connect on our network. This allows us to have our own terminology, and that's something that is very important for the court.
In 2017, the ECOWAS Commission undertook reforms which affected all its institutions. It led to a paradigm shift at the court. The number of judges was reduced from 7 to 5. Their tenure was also reduced from 5 years renewable to 4 years non-renewable.
The court sits in panels of 3. In panels of 3, so when you reduce the number of judges from 7 to 5, it means you cannot have more than one panel at a time.
With the ever-rising cause list of the court, this was always going to be tough on the court, but it has been resilient.
These 5 set of judges have delivered the highest number of judgments within a year, more than even when they were 7.
Over the years, there has been a turnover of judges as their tenures lapsed, but it has not changed the style and content of the court. The ECOWAS Court has attracted litigants for its relatively easy access, unique procedure, innovativeness, as well as its courageous interpretation and application of the treaty, text, and relevant statutes.
ECOWAS does not have its own catalogue of rights. So the courts have been very innovative in deciding on the catalogue of rights it should apply. Since its protocol did not provide or specify,
the court applies the treaty, conventions, protocols, and regulations adopted by the community, as well as general principles of law. It is equally guided by international instruments on human rights ratified by the state or states who are party to a case.
The court has itself gradually set in place its own jurisprudence in terms of the human rights that has evolved over all the years. The court, in certain cases, even declare and maybe comment about the legislation in some of the member states that these are not in line with international standards or the treaties that they themselves have signed on to.
The court held in the case of Musa Leo Keita and Republic of Mali in 2007 that simply clothing a claim with an allegation of human rights made it necessary for the court to act pursuant to Article 9(4) of the Supplementary Protocol. The Community Court of Justice, in line with its reasoning, has entertained 446 cases in the first 20 years of its existence. Litigants at the court have been as diverse as the nature of cases brought before it, with respect to a broad spectrum on human rights.
Can you confirm that you have received the application filed by the applicant and all the contents therein? Can you confirm that? Since both parties are we will proceed accordingly.
The court has also been active in exercise of its other mandates as an ECOWAS Public Service Tribunal, an arbitration tribunal, ABID, and the government of Cross River State in Nigeria.
The court has really grown in strides from its origin. I think I've appeared before the court for almost 6 years now. I think every year there's an improvement in the speed of dispensation of justice and also the court's disposition to the various litigants that appeared before it. So I think it's been a very, very positive experience.
Je viens devant la Cour depuis 2015. Ordinairement, il est difficile quand le gouvernement est impliqué d'obtenir une décision juste, une décision équitable devant les juridictions nationales. Du coup, la Cour de la CEDEAO est demeurée depuis presque 20 ans déjà le seul recours pour ceux qui sentent leurs droits violés, leurs droits humains violés, de les voir au moins entendus, même si ce n'est pas totalement indemnisé ou écouté, justifié, de les voir au moins entendus, de s'exprimer, si vous voulez qu'on le dise comme ça.
Overall, I think the ECOWAS Court is setting the standards with respect to how international human rights courts should operate. The court has been able to render decisions in average 2 to 3 years, and some of those decisions have been great, expanding, the frontiers of human rights jurisprudence.
As at its 20th anniversary, many of the 233 judgments delivered by the court have become major legal proceedings in the community.
Look through the decisions, hundreds of decisions over the last couple of years, in some cases laying down precedents, even in some cases that I have litigated. The court was the first human rights court in Africa to apply the Maputo Protocol in the Injemanze case. The court was the first human rights tribunal in Africa to rule on a case of domestic violence and what the role of the state is in responding to victims of domestic violence. The court has been the first to rule on discrimination against the girl child with respect to the right to education, and several more decisions like that.
No, one of them was about the right to education in Nigeria. And I remember that very well, that the Nigerian Attorney General, they seriously opposed that case because they felt it was against the Nigerian federal government, federal constitution of Nigeria. But then we looked at the African Charter on Human and People's Rights and declared that it's a right which every citizen must enjoy. You see, so that decision on the right to education cuts across the entire sub-region. That if there's a country which tries to put impediments in the way of anybody from accessing education, the court is there. The court has given a decision which they must accept.
Lembro também do caso, esse caso é muito importante, do Peter David e o embaixador Uche, se não estou a erro, em que este caso foi importante porque pela primeira vez nós decidimos que o tribunal não se ocupa de disputas entre indivíduos. O tribunal é um tribunal internacional, deve preservar a sua vocação de tribunal internacional e deve julgar queixas que envolvem os Estados ou as instituições da comunidade.
Burkina Faso tinha atualizado a sua legislação, onde se violava o princípio da liberdade eleitoral, que todos os cidadãos pudessem participar em eleições livres. Um cidadão recorreu e nós, efetivamente, condenamos o Estado e pedimos ao Estado que produza uma outra legislação onde todos os cidadãos possam participar livremente em eleições. Lembro-me dessa situação. Lembro-me de mais um ou outro, o Icenabré, por exemplo.
We have a famous case here in Cabo Verde involving a diplomatic person called Mr. Saab, who appealed to the ECOWAS Court.
Le rôle du juge, c'est de bien comprendre ce que chaque partie a dit par rapport à l'affaire. Une fois que ça c'est compris, le juge va à la loi et applique ces faits-là à la loi. Le juge est là pour dire le droit. Alors, c'est vrai que, exceptionnellement, dans certains cas, on lui permet de statuer en équité, de prendre une décision équitable. Une décision équitable. Mais ça, c'est exceptionnel. Mais sinon, ordinairement, c'est la loi que le juge doit appliquer. Et si la loi n'est pas en votre faveur,
without courage, you cannot give any verdict that will be seen as if it is offending a state. Because you don't look at the state itself, you look at the issue involved and the parties involved. Will this do justice? That is your primary concern.
The court's judgment in 2008 in the case of Hadijatu Mani Kurua and Republic of Niger made global history. The decision is referred to as pioneering because it is one of the first slavery cases ever to be won at the international level.
On rendait la décision, et c'est le lieu de vous féliciter, vous, journalistes. Nous rendions la décision, le temps de prononcer de la décision et de retourner à notre hôtel. Le monde entier avait l'information. Les NTIC ont publié ça partout. Et cette décision a valu à cette dame non seulement d'être reconnue comme femme battante, mais elle a été élue. La femme, je crois qu'il y a au niveau des Nations Unies, et puis je crois l'année de la femme ou femme battante, je ne sais plus quel prix elle a reçu. Elle a été invitée, c'était à l'époque du président Clinton.
That case was very significant and we were really gladdened by the fact that the then president of Niger accepted and executed the orders made by ECOWAS Court.
The court has been honored by Columbia University in the United States of America with the Columbia Global Freedom of Expression Prize for the judgment in the case filed by Amnesty International Togo and 7 others against the government of Togo. This was over the shutting down of internet services in that country during anti-government protests in 2017. The ECOWAS Court of Justice, in its decision in 2020, declared that the shutting down of internet access by the state of Togo violated the rights of the applicants to freedom of expression.
Internet being a media by which the right to freedom of expression is being exercised. Shutting down that internet, it means the means of exercising that right has been shut down, and therefore it should be taken as a violation. There was no law in existence that gave them the right to do so, to do what they did.
Decisions of the court are published in its law report, which is also available online. However, the challenge the court has faced is with enforcement. Only about 30% of these judgments have been enforced by member states.
These member states were reluctant in executing the orders of the court. Some were willing. Some executed timelessly because the protocol says the Court of Justice is a final court. You cannot appeal from its decision. So with that in the protocol, signed by all the member states, we can't see how a member state will refuse to execute, because they gave their sovereignty, part of their sovereignty, to sign that treaty. And when you have given part of your sovereignty, you have to go by the agreement.
Article 15.4 of the ECOWAS Revised Treaty and Article 2.1 of the Supplementary Protocol stipulate that the judgments of the court are binding on all the member states, the institutions of the community, individuals, and corporate bodies. The 2005 Supplementary Protocol also provided a mechanism for enforcement, and some member states appointed focal persons. Nonetheless, enforcement of the court decisions continues to be frustrated. Ironically, some of the presidents that declined to enforce the decisions of the court while they were in office have now turned to the court out of office to seek the court's intervention over alleged violation of their own rights. To commemorate the 20th anniversary of the court in 2021, it held an international conference in Lomé, Togo. This was in keeping with its tradition of organizing international conferences to seek informed contributions to the development of community law and the ECOWAS agenda. Previous international conferences discussed a range of subjects pertinent to the mandate of the court as well as community interests. The theme of the 2021 International Conference was 20 years of ECOWAS Court of Justice, achievements, challenges, and prospects. Various segments of the West African community celebrated the unique human rights mechanism of the ECOWAS Court of Justice and its contribution to human rights jurisprudence in the region. The issue of enforcement of the court's judgments preoccupied the conference.
I think the court has gone a long way. It has really reassured the citizen of ECOWAS. It's one of the most successful courts that we have on the continent, and a court that has really provided value added to the community agenda. And the challenges of implementing the decision, of course, has raised some issues that need to be addressed.
After 20 years,
The Community Court continues to act as a beacon of regional peace, and we have already seen and heard how its decisions have led to myriad changes in law and practices across the West Africa sub-region. We also take due cognizance of the fact that the reputation of the court is being brought into disrepute by slow, partial, and even non-implementation of its rulings. All laws must be obeyed, and all court rulings must be adhered to.
Overall, the jury is out on the performance of the court as it commemorates its 20th anniversary.
That the court is existing for me, I think it's one great achievement. And it's not just alive, but it has really set the standards amongst the international human rights organizations as one that is seen to be progressive in its interpretation of the statutes.
O maior desenvolvimento do nosso tribunal, a maior expansão, foi realmente com a abertura a estas situações onde os cidadãos possam efetivamente ter acesso ao tribunal. Antes não se podia, era só Estados, porque é comunidade de Estados. Mas hoje, portanto, abriu-se e a maior parte dos casos que o Tribunal de Justiça da CEDEAO dirime entre cidadãos e Estados por violação dos direitos, liberdades e garantias fundamentais dos cidadãos. Mas tem havido uma projeção grande das nossas decisões fora do continente, precisamente por esta perspectiva de violação dos direitos humanos.
I think the court has played an immense role in contributing to human rights. I think it's a dual-edged role. One, the court serves as a deterrent in one role, and the second role, it serves a good role of promoting human rights as a deterrent, for example, in its judgments and calling out governments and calling on governments to do better. It creates such a deterrent that other states really do not want to appear before the court and be held responsible. So they tend to toe the line and respect human rights.
It has established an effective, very effective human rights mechanism, a human rights mechanism that is very unique, a human rights mechanism that has been resorted to by former heads of state, former presidents in the ECOWAS ECOWAS space, by high and mighty, by the indigent, by the poor, because it's a court that has proven to be bold, authoritative, and independent.
The Court of Justice function, execute its mandate without fear or favor or without being directed to by any sources, because the court is financed fully by the people and the court works for the people.
Dever o tribunal a continuar o seu trabalho e a continuar a granjear o respeito dos Estados-membros e também da comunidade jurídica que integra a CEDEAO.
As Chief Justice, I have seen the East African Court operate, I've seen SADC operate, and one uniqueness I think we have here is that in this court, there's no need to exhaust local remedies. And that gives relevance to this court.
Os 20 anos do balanço do funcionamento do tribunal, podemos dizer que é positivo, na medida em que alguns estados já estão a implementar, portanto, executar as decisões do tribunal. Naturalmente que alguns ainda, portanto, estão a resistir.
People should not be denied the fruits of their judgment. If you have a judgment that is pronounced by the ECOWAS courts, national courts should be in a position to enforce those judgments.
Unless member states comply with the judgments of the court, it will be difficult to build public confidence in the court.
I know at the end, the member states will give themselves the acknowledgement that they have set up a viral court that is serving all the members of the community, ECOWAS.
The court gave eloquent expression to its vision for the West African community in the case of El Taiba and Republic of Sierra Leone, where it declared that for the avoidance of doubt at this stage of development of international human rights law regime, persons, including states, must be careful with regard to the treatment of their nationals or citizens and other individuals within their territorial jurisdictions. Where their acts or omissions towards such persons violate their rights as enshrined in international instruments, an international tribunal such as ours will have no alternative than to hold them answerable for the wrongs. The era of gross impunity by member states and their governments in our sub-region shall no longer be tolerated. From 2001 to 2021, the Court has been delivering on this mandate to the West African community. As it enters a new decade, the Court is also looking towards making more history by extending its role on the judicial landscape of West Africa.
Now we see the cry of the citizens. Now they know more about the court. They are pushing for more cases to be filed. If we have two panels for the cases to improve, and then also the appellate court to test the judgment of the court, to be a star of Africa.